Okay, very good. Okay, I'm going to say that again. The reason I wanted to do this event today is because I've had the medical board visit 2 of my clients this month. And one of them is more serious than the other, and they were both what we believe are anonymous complaints. And it just, they were, and they're in, now, this is what happens. As soon as I get on Zoom, my dogs lose their mind. 1 second. What do you want, Grace? And if you've met my dogs, you understand. It's like having 2 3-year-old children in the house. One of the med board visits seems less dramatic than the other one, but they asked similar questions of both of them. So I just wanted to run through several topics with everybody so that we're all doing our best to keep ourselves compliant. So I'm going to do a screen share now with my fabulous PowerPoint. And that is where? Right here. And we'll share. No, that's not it. What the heck? Okay, I'm a moron. 1 second. Okay, here's the PowerPoint. Now let's go back to share. So you can tell I'm a technological genius. Okay, share screen. And it's right here. Yay, share. Okay, and I'll go to full screen. Okay, so we're going to talk about the intersection of business, medicine, and the law. And I talk about this a lot with everyone. And, I talk about these subjects all the time, but this is a really good opportunity to just have a review and make sure that everybody is as compliant as we possibly can be. Of course, everybody's in business to make money and we want to keep the bank happy and healthy. And but our most important focus is that we're practicing medicine and we're taking care of the patients. And we're thereby going to be in compliance with the laws which are governed by the medical board. So the big question that is being asked when these med board agents come in, investigators come into these practices, the questions all revolve around who has control of the practice. And we have, a couple different models. We have the MSO model where there's, someone who's a nurse or an esthetician who has the idea for the business and forms the management services organization. And then we have a medical practice, and that's really the primary business of a med spa is the actual medical practice, which is the medical corporation, which is at least 51% owned by an MD. And as you all know, the other 49% can be owned by another licensed medical professional like a chiropractor or a dentist or a PA or an RN or an NP, or, there's various other licensed medical professionals that can own that 49%. And a lot of times, the MSO is really running the business of the business and kind of forgets that this is a medical practice. And so when anyone asks any questions about what is this business, this is a medical practice. And that MedCorp is the primary business that is operating in that space, and that's the medical practice. So I'm going to go to my third and final and most exciting slide here. And this has a list of things that we want to think about. And I had sent an email out about this a week or so ago when the first med board visit occurred. I was on the phone with one doctor, and someone else from another practice texted me and said, the medical board is in my office. I think I said that in my email. And this is not a text I'm happy to get, and none of you want to open your door to the medical board investigator showing up at your office. I had a client once who called me and said the DEA is here because there was an issue about where that particular practice was buying their medications. So the first thing we want to look at is the lease. And the lease for the space that you're in should be in the name of the medical corporation, or it can be the primary lessor or lessee, can be the tenant, can be the MSO, but then there must be a sublease to the medical corporation, because what did we say? Who has control of the practice? If the medical practice doesn't control the space, they don't have control of the practice. So we want to make sure that that space is in the name of that medical practice one way or another. And if you're not sure, you know, I will be happy, send me the lease. I can do a lease review. I do these lease reviews. I try to do them before clients lease their space so that we make sure that everything's lined up and the, you know, the entities are properly identified, because there are things in those leases that I looked at one lease recently where the landlord, you know, was allowed to come in there at any time. And, you know, some of these landlords do this licensing situation where it's not a lease, it's called a license to use the space. And that, the way that they're drafted gives less control to the tenant, but it allows them to kind of circumvent a lot of landlord-tenant laws. That's the reason that they do it. At any rate, that's one of the first documents we want to look at to determine who has control of this practice, and make sure that the medical board is either the primary lessee or the sublessee to the MSO. Most landlords will request a personal guarantee from the principals of one or both of the entities. So, and that, you know, that's normal. And some of you probably already have that and know what that is. DSAs, okay, delegation of services agreements. As we know, there were new laws that came down regarding physician's assistants at the beginning of this year. I am erring on the side of caution, and I'm still making sure that we have DSAs in place even for PAs, just because we want to appear that we're going overboard, giving control of the practice to the MD. If it's an NP who's doing the good faith exams, then for sure we need that DSA in place. And let's review the DSAs, because the DSAs I send out on the second page, there are 3 options, and one of those options should be checked. And I don't think that we're necessarily checking off one of those options. So make sure you look at that second page. And if you don't know which option you want to check, when you talk to your doctor, let me know, and I'll help guide you through that. Equipment leases. The equipment now, if you're leasing from the manufacturer, they won't lease to anyone but a medical practice. If sometimes practices will buy secondhand equipment, and sometimes the MSO will buy that equipment, we have to make sure that it's in the name of the practice. So we can prepare a sublease or a lease from the MSO to the practice, so that the practice has control over that equipment, because it's FDA controlled, and the practice should be on title, so to speak, on that equipment. The practice should, while I'm on it, and you probably already know this, but I'll just go over it just in case. The practice should be buying all of the medical equipment. It should be buying all the meds, and it should be purchasing any and all medical grade skincare. And if you're buying from manufacturers or companies that produce these products, they have to sell it to a practice, but make sure that the purchasing is running through the bank account of the practice. And of course, the practice is going to be paying the payroll to all the providers. Protocols. So this is something that was asked for by the medical board of one of the clients that they visited. And the protocols are, if you don't have them in place already, they're really essentially the protocols provided to you by the manufacturers of whatever meds you're using or whatever equipment you're using. So there's always a pre-treatment, pre-treatment screening for a patient. And there's, pre-treatment care. There might be some kind of precautions a patient should take before they come in for a particular procedure. And we want to make sure that we have them sign off on the potential side effects or potential problems that a particular procedure could cause, and the aftercare procedures. So these are all in your protocols. And they will also provide protocols for the treatment provider. Those go in your protocols. I usually also add, what we're going to talk about next, which is an emergency plan. We should have an OSHA Sharps plan in there, which are, I have those on file. I can just make sure they're updated to 2020 and provide those to you. But these are all things that should be in your protocols. Your protocols should be updated annually. And all the treatment providers shall have signed off on those protocols, whether in hard copy, you all know I'm old, I like paper and books, but you can have them, you can provide them electronically and have your treatment provider sign off electronically as long as you save that. And you want to make sure you save them from years past. I had an incident with a client one time where I want to make sure that, I'm sure it would notify me if anybody else was trying to get in. It would, where they asked for, there was a complaint from a patient, and notice we always say patient, not client. We want to make sure that that our words match what we're doing. There was a complaint from a patient about about Botox that she came in for a Groupon, and it was, of course, Groupon can easily turn into drama. But the med board, it was the nursing board that she complained to, and this poor nurse was new, and she had just gotten certified to do injectables, and big investigation ensued. And one of the things they wanted to see was, so this had happened, in the prior year, because these things take a long time to get to the point where they're coming in and actually investigating. They wanted to make sure that nurse, that they had a copy of the protocols from the prior year that nurse had signed off on. So make sure you keep those, and I would say keep them for at least 5 years. I keep all records for 10 years, even though in my engagement letter it says I destroy them immediately, but I do keep them all in boxes for 10 years. So you want to keep them. The other thing you should have in there is your emergency plan, and you should have an emergency plan in place. What is the hospital that is closest to your practice where you will take patients or send patients if something goes wrong in the office? Now, with medical aesthetics, the most serious thing that could probably happen from treatment, as you all have told me, is, an allergic reaction to something. However, that patient could come in with some kind of medical condition. They could have a heart attack in your space, and you need to have an emergency plan to deal with that. So where are you going to take them or send them when you call the ambulance? And that should be in your set of protocols. And I'll just move down. What is your emergency plan in the event of an incident or allergic reaction, like some kind of reaction to the treatment? Do you have an anaphylactic shock treatment kit on site? You should have that on site. And you as MDs or the MDs that are your medical directors, you should have a discussion with them about what treatment kits that you should have on site for in the event of emergencies. So the MDs. Now, if we have the MSO operation, where you have the MSO and the medical corp, how often is the leader of the MSO, typically an RN or a PA, if they're treating patients, how often are they meeting with the MD? And the answer should be at least once a month. That seems to make them happy. Client has been asked by the med board, what do you talk about? And you should be prepared to tell them, if they come into your practice, what you're discussing with the MD. And what should you be discussing with the MD? MDs, you can weigh in on this. You should be discussing what treatments you're providing at your particular practice and how it's going with the patients, treatment plans for particular patients, what you're going to be doing moving forward, if there have been any issues, any incidents, any allergic reactions, anything that's come up in the last month in the practice. And what percentage of the charts does the MD sign off on? Well, kind of the old rule, that we've talked about is that the MD should be signing off on a minimum of 5% of the charts. The more charts that MD is signing off on, the better you are going to look if the med board comes in and starts asking you questions. So it's just like having that DSA for PAs, even though it's not required as of the beginning of this year. I always recommend going a little bit over and above what the minimum requirements are. It just makes you look better. So you want to make sure that your MD is signing off on, a good smattering of the charts every month. Another question that was asked is, who makes the final decisions about patient care? Well, of course, it's the MD, because the MD has control of the practice. Now, there are things that are delegated clearly to the PAs and the NPs and the RNs. And RNs are perfectly capable of making, certain limited decisions about patient care and treatment. But they've had a good faith, the patient has had a good faith exam, either by the MD, the RN, or the PA, or the NP. And they've been cleared for whatever treatment it is. And oh, by the way, I recommend that you do your GFEs annually, because this patient conditions can change. They may have a new allergy, and you might even ask them every time they come in, do you have any new allergies? Has there been any change in your health, in the status of your health since we saw you last, whether it was 3 weeks ago or 3 months ago or 3 years ago? I think it's a good idea to always ask those questions, because you never know what's going on with that patient. And as you know, patients don't tell us everything. It's just like clients don't always tell me everything. Even though we as professionals try to put ourselves out there as a safe space for our patients and clients, sometimes it just doesn't enter their mind that this is an important thing. So we want to make sure that we're asking those questions when patients come in. I already talked about emergency plan in case of an incident or allergic reaction. And also, you should always make an incident report if the least little thing happens, because you never know what that might grow into over time. I had I'll just tell you a story about a client in another industry. This person has a martial arts studio, and last July or August, a student was in there, and she was, not a spring chicken. She was like my age, and she fell. She tripped over something on the mat. They were doing forms, martial arts forms, and she sprained her ankle or did something to her ankle. Well, now she never complained. She went to Kaiser. She did the whole thing. She was totally fine. Sent my client happy birthday messages. A year later, she now is claiming that another instructor in the studio walked by and swept her, meaning kicked her leg out from under her, which caused the injury. Now, she never told anyone this before. She never told her doctors this before when she went in to see them. So it's clearly questionable. And my client, of course, says that didn't happen. But the point is that when people get stressed because of other things in their life, and right now COVID is the big thing, and it's causing a lot of stress on every aspect of people's lives, you never know what they're going to do. So we want to always make sure we have good records, which includes incident reports. If the least little thing happens, I mean, if they get a little red spot or swelling, I would notate that down, at least so that you have it in the chart, and follow up with them and make sure they're okay. Another question that the med board asked one of my clients, who's the available MD in the event that the medical director or primary doctor in the practice is not available? So if you have treatments happening, being provided when the MD is not around, and your medical director can be contacted, and you should have immediate access to your medical director, either by phone, by Skype video, or they should be in the space. If they're not in the space, they've got to be immediately available. And for you MDs who are running your own practices, who is the MD that's available in the event that you're not available? If you have treatment providers that are treating patients and you're on vacation to Mexico or somewhere else, who's the MD that's available? And it might be the answer might be, it depends. It depends on what the issue is that comes up, and it depends on who else is available at that time. So when you go out of town, like when I go out of town, I'm required, if I have matters pending in any court system, I'm required to file a document that says, I'm out of town and unavailable, and this attorney is available to handle any emergency issues that come up with my cases. And you all MDs should have the same type of thing, where when you go out of town, or if you have a medical situation happening or a family situation happening, you should provide your providers with some kind of document, even if it's just an email. Here's the doctor to call in case something comes up while I'm gone. This was, they dug kind of deep into this one. Here are some other things that aren't necessarily med board issues, but they are important. Is your FNP up to date, your fictitious name permit? So all of my clients have medical corporations, and I don't think I have one. I might have one who might be on this Zoom, who did not require a fictitious name permit from the medical board. I have had investigations where the FNP was not up to date, and they didn't make a big deal out of it. They mentioned it. There was no fine, no penalty, no nothing. But we want to make sure that all of our ducks are in a row. And if you open a second practice, there's this particular form that has to be filed. If you move locations and change your address, there's a one-page change of address form that needs to be filed with the medical board, so that they know exactly what's going on with your practice. And the whole purpose for that fictitious name permit is to prevent fraud on the public. In naming businesses, there are a couple different avenues that are used that are the reason for naming. One is to protect your name, so that you have rights to your name as the first user of that particular name against all subsequent users, so that you can protect your name and your goodwill. But the other one is to protect the public. And this allows the public to find out who the individual is, in whose hands that buck stops if something goes wrong. In California, personal service is required for a summons and complaint. And that member of the public must be able to determine who that person is. And they also need to be able to determine who the MD is. And for us, for MDs and attorneys and architects and CPAs, we are personally liable for all professional negligence. So they have to know exactly who that MD is, who's in charge, where that buck stops for that particular practice. That's the whole purpose for the FNP. Here's something that the med board hasn't necessarily asked about, but it's really important for a couple of reasons. Is communication with patients between staff and or providers, is it HIPAA compliant? And I know there are practices where providers and staff are communicating with patients by text, and this is a big NO. And I'm really adamant about not having text be your primary method of communication for business and legal matters, because it's hard to track. I just had a hearing yesterday where text was a big deal, because that was the evidence of the communications between the parties. And it's a lot more difficult it's easier to edit and change, and it's a lot more difficult to track as far as timeline goes when it's done by text. So when things start getting serious or adversarial, I always recommend that we move to email. But going back to the HIPAA compliant issue, I know there are programs, I can't remember the names of them. I have them on my phone for when I've been to your practices and had my before and after pictures taken and had communication with the practice. where you communicate with the patient through a specific app that is HIPAA compliant. And I believe, I've been informed by one of my clients, I can't remember who it was or what the app was, but there is an app that allows text communication with the patients through the app so that it is convenient for the patient and it remains HIPAA compliant because it goes through a secure portal. But the other issue about this texting with patients is that there is a trade secrets issue. So one of the big challenges that you all have in your industry, and it's all over in the beauty and service industry, and that is providers leaving and taking patients with them. And I've given almost everybody, and if you don't have this, let me know, a trade secrets policy sheet that just reiterates California law regarding trade secrets, and we state that patient contact information is a trade secret, and California law says that employees shall not utilize trade secret information to solicit patients, clients, customers of their employer. So if you make an effort to keep your patient contact information a secret, in other words, the whole staff and every provider doesn't have immediate access to it. They have to go through a particular system to get in touch with patients, and they can't just call them or text them themselves or schedule with them themselves. Then you've protected your patient information as a trade secret. And if those providers leave your practice, they cannot use that patient information to solicit those patients. They can rent a billboard, and I've told people this, you can rent a billboard, you can go on Instagram and say, I am no longer at practice A, I am at practice B, period. What you can't do is say, and patients of practice A, come see me and I'll give you a 10% discount, or make particular invitations to patients of practice A. That's a no-no. And it's the same thing with other providers or employees of practice A. You can't use trade secret information, which would be anything in the personnel files, to solicit other employees to come away from practice A to go to practice B. So patient protection being HIPAA compliant, but also protecting your business as well. The last thing I want to mention is insurance. And we should be making sure that our malpractice insurance is reviewed annually. I know that I renew my malpractice insurance annually. And so of course I review it. But if you're bringing on for instance, if I brought on a paralegal or another attorney to work for me, I would make sure that I reviewed with my malpractice carrier, to make sure that that person was covered. I've had practices who've changed medical directors and not update their insurance, and that's a big problem. We always want to make sure our insurance is in place and that it is updated to who we have working in the practice, medical director and all providers. So that's my cautionary tale for today. I'm going to stop the screen share and see if there's any questions in the chat. If anyone has any questions, no questions. I hope this was valuable to you all. I know I have some new people that are clients, and I hope this was valuable and informative to you and really explained kind of the process and what the focuses are. This is recorded, and I will be sending it out to everyone on the email list. If you are, there's a few people on here that I can't tell who you are by your phone number. If you're not on my email list, tell whoever invited you to have me put you on my email list so that I can send this out to you. Okay, I'm glad you loved it. And so that was awesome. We did that in a half an hour. So go have a fabulous weekend, my beloveds. And as I said, email me with any questions that you have. Undersea, thank you so much. It's a great reminder. Yeah, stay up to date. Very good. Yeah. Okay. Have a great day. Bye.